That means no.
Is that Jenny B?
Jenny B.
Is Jenny B in the house?
Jenny B, I'm listening in. I have to head to an appointment, but I didn't want to miss this one. I'm going to listen as long as I can.
All right, Jenny works with the Spitz Camera Group. She joined us a couple years ago.
Oh.
She was formerly a writer in TV. Her ex-husband was a producer, and she's amazing. So she's a great asset to our team.
Thank you, Andrew.
Besides being beautiful. Hopefully that's not sexual harassment.
I'll take it. I'll take it.
I'll remind you again.
No, but she's beautiful inside, she's beautiful inside and out. She's sweet, sweet soul. Really sweet soul. I love you.
Thank you. I love you too. Thank you, guys. I'm blushing, but you wouldn't know.
I can tell. All right, you can start. You can start whenever you want, Doron.
Okay. Well, last time we talked a little about estate planning, and I think that's what you want to hear about a little bit today. So let me ask, are there any specific questions anybody wants to talk about?
Well, you could repeat some of it because
Okay.
I don't know how much everyone's retained. And, I've talked about it. I actually called a few of my older clients, one that couldn't be on it today. She's probably in her 80s, and I'm going to send her the link. And I told her, I go, which I remember, but I didn't remember you brought out some points like, your plan should be reviewed every, whatever it was, 3-4 years, because there's changes and there's people that don't make the modifications as things change. And as I said before, I've had clients who are lawyers that I look and I shake my head because they have their house and it's not in a trust. And it's a lawyer who doesn't, it's like, what are you doing? You got to get a trust. Or these doctors.
I stopped being shocked years ago. I've been dealing with this financial advisor as a trustee of this very large trust for a client, and it's actually mother-in-law had died, and so he's the trustee. His wife is one of the beneficiaries, and she's inheriting some real estate. So we put it in her name, and I told him you should contact your attorney to put that property into the trust. And he goes, "We don't have a trust." A lot of people don't. It just,
I know
they don't. But
I spent the last week talking to some of my clients, and not to share grief, but my father died when he was 50. I'm older than my father already.
Oh my gosh.
His estate was in a mess, and so the people I've been talking to about this Zoom meeting and other clients, even before I thought about doing Zoom meetings, I've been preaching to them about it, how important it is, because I tell them, you work all these years and you do it for your family. And when you're gone, you don't want the government to take your money or majority of your money and leave your family or who you love without what you intended or wanted.
Yeah.
So people don't want to deal with the mortality or thought of death, and it's hard.
It's very hard. By now, 20 years ago, we weren't having the same conversation. People want to know about trust and this and that. Nowadays, most people know about trust. The main purpose is to avoid probate. So things don't have to go through court when you pass away. Probate is a 2-year procedure in LA County right now. It's really expensive in terms of lawyers' fees. And it's all public, so people can find out what you had, what you were worth, and what your family is inheriting. And when I say the attorney's fees are expensive, if a client has a $2 million house and they owe $1.3 million on it, the lawyer gets paid a fee based on the $2 million gross value. That's set by California law, and the fee on that's somewhere in the neighborhood of $33,000. It's lawyers love probates. I don't like them. I think they're a waste of time. The easier way to get around that is to have a family trust, a living trust, and you put your assets in the trust. And then when you're gone, the trust acts like a will and it distributes to whoever it's supposed to go to. And it's done much quicker, more cheaply, and privately. And I think by now, most people know what it does. The key, though, is not just setting up the trust. It's making sure your assets are coordinated with the trust. So if you have real estate and you haven't put it in the trust, or you refinance, taken it out and not put it back in, and you pass away, what will happen is you'll have to have a court petition filed to have the asset put into the trust. It won't be a full probate. It's something called a Hegstead petition. But still, it takes time, it takes money. And so the key is not only setting up the trust, but making sure your assets are coordinated with it. There are assets that don't go in the trust. You don't put your cars in the trust. Small bank accounts where you regularly keep less than 10, maybe $15,000 don't have to go in the trust. If you have a corporation that you own, your stock should be in the trust. If you have LLCs that you've invested in or that you have your real estate through, those should be in the name of the trust. Life insurance has beneficiaries. General rule is we tell people to name their trust as the beneficiaries. We'll talk about that in a little bit. Retirement accounts are more problematic. Again, you name beneficiaries. The dilemma is this: you can certainly name a spouse, but if you name your living trust as the beneficiary, what ends up happening is that when you pass away, the income taxes all have to be paid on that retirement account within 5 years. So naming your family trust accelerates the income taxes. If you have children, you can name your children, but if they are not old enough to get the money, or they're minors, then that's not a good situation either. If they're minors, the money will get caught up in court and the income tax are due right away. If you have your kids getting the money at, say, ages 30, 35, and 40, and today they're 20 and 22, and you name them as beneficiaries of your retirement accounts, that's not what you want. You want that money held until they reach 30 and 35. So the way to avoid these issues is to set up a special IRA trust. There are federal regulations where you can set up a trust where the money goes into the trust for the kids, but they don't have to pay the tax within 5 years. They have longer to pay the income tax. So it allows it to grow tax deferred, which is good. So your family trust is your starting point for how to hold your assets, but not everything goes in it. You have to be careful. It all depends on what you have. Again, the trust will act as your will, so it tells us who gets what, when they get it. It can do some estate tax planning that we'll talk about. But, again, your kids, if you have younger kids, as they get older, you want to review your trust because you want to see if the ages you picked for them are correct. Are the people you picked as trustees take care of the money still the ones you want? Those are the two things that change the most when people have younger kids. They either watch the kids get more mature or less mature, and over time, they generally change the trustees. So it gets very interesting. I'm sorry. Somebody said, "Can I ask?"
This is Steve. Yeah, this is Steve. How are you?
You're in your rolling office.
Yeah. So I've known Andrew a long time. Thank you, Andrew, for inviting me onto this Zoom call. I have a trust, and I own a lot of real estate, apartments, etc. And I just found out, because I haven't been paying attention, that our home in Toluca Lake was never put in the trust. That all my assets are put in the trust. And I even think our stock accounts are in the trust. I don't pay attention to this stuff, and that's the problem. And we have various bank accounts with more than a few $1,000s in them. And I was told by one of my attorneys that, well, it doesn't matter if you die, God forbid, you and your wife, it would go automatically to the kids because you already have a trust, and they would just assume that the house is theirs. You wouldn't be tied up in probate. I don't think that's true. I think what you're saying, that I would have to now convert the house into the trust. Is that correct?
Yeah, if your house is not in the trust and you pass away, then in order to get the house into the trust, there's something called a Hegstead petition that has to be filed with the court. It's basically a summary probate that you ask the court to say, we intended it to be in the trust, but we never put it in. Can you please treat it as being in the trust? It ends up running a few $1,000s and taking over 6 months. It could take 9 months to a year. The courts are that backlogged. So I don't think, if that's what you were told, I don't think it's accurate at all.
No, and Steve, on a title perspective of transferring the property, if let's say your kids wanted to sell it, we would require a probate or a Hegstead petition on that. We would not let them transfer just because it should have been. We would require those things. So definitely listen.
All right. Well,
again. Go ahead.
Sorry, I was going to say I'm in need of a good trust attorney because I think I haven't had my trust looked at since 2003, and there's been a number of acquisitions, etc. And you know, we have 3 kids and my wife is not going to, you know, get involved in it. So if somebody could give a number to Andrew that I can call them, I would love to have a meeting with them and, you know, have them look at my trust and update everything and get me on the right track.
Steve, everybody's going to get a copy of his number, and he is the best guy to speak to. That's why he's on the Zoom.
I appreciate this. I really.
Yeah, I don't think, Steve, I'm an estate planning attorney.
Oh,
Yes,
that's what I
say
mean.
that.
Thank you.
Yeah. And it may be, even though you haven't looked at it in 17 years, it may still be okay.
I don't think so.
All right.
Not what you're saying. I don't think so.
Okay. All
He's
right.
bought a lot of real estate. He's bought a lot of real estate in 17 years.
Yeah. Yeah. So again, that's the trust. As time goes by, you look at who do you want to have as your beneficiaries, the guardians for the kids, the trustees. You know, you'll find kids mature at a different rate. Some kids may have issues that others don't. A big issue today with a lot of people are kids that have, I don't know what the PC word for it is, but disabilities or cognitive issues, or they might be on the spectrum. Okay.
Sure.
When you do that, when you have people who are either getting SSI or Medi-Cal, those are government benefits that are intended for people who don't have assets and need governmental assistance. So when I say they don't have assets, that means you have to have less than $2,000 in assets. If you have more than $2,000, you don't qualify for Medi-Cal and SSI on a needs basis. Okay, the number is silly as far as I'm concerned, but that's what it is. It hasn't been changed. So the dilemma is this: if there is a person who's getting Medi-Cal and SSI, and their parent passes away and leaves them money, whether it goes to them directly or it goes into a trust for them, they are considered as owning it, and they will lose their government benefits. So the only way to avoid that is to set up a special trust for them called a special needs trust, which allows them to continue to qualify. So again, you have to keep looking at this. Things happen. And if we have a client who happens to, you know, we have a client, their child has a special needs trust. One of the questions we ask the client is, are there grandparents or anybody else that are going to leave this child money? Because I can do the greatest planning in the world for this child, set up a special needs trust, and if the grandparents die and they leave the kid 50 grand, the kid will lose their benefits. So you got to coordinate the family together around. So again, depending on the situation, every family has its own fact and what happens. See that so far?
I lost you at hello.
Pardon me?
I have a
I
quick
gotta
question.
I was going to say, Jenny, I don't know how you keep that smile going.
I know, it's a gift I have from my mother.
Yeah.
I'd love to get your number and talk a little bit more. But, you know, being in real estate and all of us working in very lawsuits type of environments, the only thing that really can protect your assets are the irrevocable trust, but then you have no control over it anymore. So you don't probably recommend that, do you?
Well, the irrevocable trust, first of all, revocable trust, which is what we've been talking about, is when you can change. An irrevocable trust, you cannot change. So if there are different reasons for using it. So for yourself, you would use it either for tax purposes, or you might want to use it to protect your assets from creditors, from lawsuits. The dilemma there is California does not allow you to put your assets into an irrevocable trust for your own benefit and still be protected. It's not allowed in California. There are states where it is allowed: Nevada, South Dakota, Alaska, Wyoming. So you can do it there, put the assets in the trust and be protected. The question is, will it work if you're a California resident? If you're a resident in one of those states, it does work. And asset protection attorneys will tell you, look, the idea is to make it so muddy that nobody's going to sue you. It's too complicated, they'll want to settle. But in California, you cannot set up an irrevocable trust for yourself and be protected from creditors. So you have to look at what it is you're really protecting yourself from. If it's an error in your business where you can get errors and omission insurance, try to get as much as you can. If you're worried about tenants suing you, you can look at setting up LLCs. There are limitations to how LLCs can protect you, but it's another form of protection. So you kind of have to look at each situation and see what's going on.
Wouldn't also a large, extremely large umbrella policy? One of my uncles is a judge, and he advised me to have the biggest umbrella policy. Yeah, he said, take your net asset, net worth, and double it, and buy an umbrella policy for that. He said it's the best protection because attorneys go right for that.
And it's also cheapest. Umbrella insurance is cheap.
It's great.
I tell all my clients to get umbrella insurance, you know, and people don't even realize. They go, you know, my kids are, you know, 8 and 10. I'm worth $2 million. I got a $4 million umbrella. I go, that's wonderful. The problem is when those kids start driving when they're teenagers, you better double that umbrella because those kids are going to get in accidents and you're liable for whatever they do. So it's a constantly evolving situation which you have to look at. If you own a rental house that has one tenant, you might look at that and say, okay, here's how much umbrella I want. But if you have an 8-unit apartment building and something goes wrong, you might need a lot more umbrella than that, because if something goes wrong in the building and harms multiple people, it's a much bigger risk. But umbrella insurance is cheap. It really is. And yes, you should have a lot of it. Jenny, does that help a little bit?
You're weight in gold. I'm taking furious notes. I'm going to leave you, but I will be in touch with you. I'll get your number from Andrew. Thank you. I love it. Thank you very much.
You're welcome. So let me talk about a couple of other things. Anybody just interrupt me whenever you want.
Bye, Jenny. Good luck.
If you want to interrupt me, I'm cool with that. Raise your hand just so I can see, and I'll stop talking. Two recent things that have happened that suggest you ought to review your estate plan and probably change it. So the first one is what I talked about, those IRA trusts you set up for kids for your retirement accounts to defer the income taxes. The law changed on those in 2019, right at the end, effective January 1 of this year. If you have any of those trusts, those need to be revised. That's number one. Number two are healthcare powers of attorney. Who gets to make medical decisions for you if you cannot do it for yourself? Everybody needs to have them, okay? It's probably one of the most important documents you have. But here's what's happened in the past. In the past, we said, you know what? Pick people who can make decisions for you, but they can be there, because doctors don't want to take instructions over the phone. They want to see the person they're dealing with. They want to know who they're talking to. And the same with hospitals. With COVID hitting us, most people cannot be there. Okay, they can't go to the hospitals, they can't go to doctors, or they don't want to. So we've changed our healthcare powers to now allow doctors, hospitals, healthcare providers to accept instructions by phone or virtually, and they are held harmless from doing that. So they don't have to worry about getting sued. So again, I recommend that you take a look at those. And if you don't have those in your healthcare documents, you consider having those. Okay? We okay so far? Very quiet. All right. So let me do this. Let me talk about what's going on for a minute with estate taxes and have that kind of bring in to what's going on. So when a person passes away, if they leave everything to their spouse and their spouse is a US citizen, there's no estate tax until the second spouse dies. If the surviving spouse is not a US citizen, you've got tax issues that you need to address. So let's put that aside for the moment. So if a person passes away and leaves everything to their children, the way you determine whether there are estate taxes is by adding up the net value of all assets. Remember, I said for probate, the lawyer gets paid on a gross value point of view, but for taxes, estate taxes, death taxes, it's a net value. So you add up all real estate, investments, LLCs, businesses, if people owe you money, the promissory notes, all your retirement accounts, life insurance, death benefits, everything. Just add it all up. You come up with a number of what the net worth is. From that, you subtract how much you can leave estate tax free, and the difference gets taxed. Okay, very simple. If a person dies today, they're worth 15 million. The amount they can leave estate tax free today is 11.58 million. Let's call it 11.5 million. So they would be an estate tax on the excess $3.5 million. Their net worth of 15 less their exemption of 11.5. The estate tax bracket today is 40%. So on that 3.5 million excess, there would be a tax of $1.4 million that the government would get 9 months after the person died. Does that make a little sense so far how it works? Okay, so here's the situation. That 11 million, 11.58 has been going up. The law is it's going to keep going up by a bit every year. Not a lot, but 100, 200,000 a year until 2026. On January 1, 2026, that exemption is scheduled to go back to about $6.5 million per person. So it's going to drop. That's the law. The only way it won't drop is if Congress decides to extend the 11.5 million. Now, in the past, they've always done that. So a year ago, I would have told you, yeah, they'll extend it. I wouldn't worry too much about it coming down. Now we have concerns, and I'm to tell you why. Number one is there are a lot of people yelling about the wealthy paying taxes. And so you can see a lot of pressure to raise estate taxes. And there's two ways to do that. One of which is just lower the exemption and you collect more estate taxes. The other reason is the government needs money. COVID has put us in a real pinch in terms of money. We're no longer talking about hundreds of billions of dollars and deficits. We're up in the trillions. Okay, they're predicting COVID could cost the government $17 billion. All right, so they're gonna have to raise taxes. That change in the law I told you about with the retirement accounts earlier for the IRA trust, that Congress actually said we're doing this because we have to raise taxes. So this is going to be a relatively easy place to raise taxes. Income taxes are a hard sell for politicians. You can see what's going on right now with it. The state taxes are a tax on the wealthy. So most people in this country go, well, that's okay. And you have to understand only about 0.5% of the country is worth $1 million or more. Okay. That's just a fact. Very few people are worth $1 million or more. If you took a house in Encino and plopped it down somewhere in Kansas or Arkansas, it's not going to be worth the same amount of money. So when you realize that, the question now becomes, what do you define as wealthy? Okay, is $11.58 million wealthy or is $6 million wealthy? Well, for the person who's worth $800,000, it doesn't matter. Either one of them looks wealthy to them. So I think you will likely see that we will not extend the 11.5 in 6 years. Now, having said that, here's the problem. Joe Biden wants to reduce the exemption right away in 2021 to $6 million. If he gets in and he gets Congress, he has said, I'm going to reduce it to 6 million and I'm going to make it retroactive to January 1 of 2021. Now, that's a bigger reduction than 2026, and it would likely happen. Bernie Sanders would like to reduce it to 3.5 million, which would create an even larger estate tax. So we've got these issues. If you have clients who have very large estates, meaning they're worth more than they can leave estate tax free, they should consider doing estate tax planning. Now, it's not for everybody, so you've got to make sure it fits their situation. But if you have a client who's worth, let's say, 25 million, and they have 11.5 million they can leave tax free.
Doron,
and if they gave that
I just want to let you know we have 5 minutes left, so I'm just letting you know.
Okay. Well, in 5 minutes you can drop off. I'll keep going.
Sorry.
No, it's okay. All right. So what ends up happening is if they can afford to give away the 11 million today, they can give it away to their kids, still have 14 million left to live on. And you've saved a lot of taxes, because if they don't give it away today and the exemption goes down to 6 million, you lost the ability to give away $5.8 million. So if people are thinking of doing that, they should do it before the end of the year. If they do it next year and they change a tax, it'll be retroactive and won't work. Let me hit a couple of other points real quick. People have life insurance. A lot of people have gotten rid of their life insurance over the years. They don't need it anymore, or they got it for estate taxes, but the exemption went up so high that they felt there are no estate taxes. If you have life insurance, do not get rid of it, even if it's term. For right now, don't do anything, and here's why. even if you don't feel you need the life insurance, if they reduce the exemption and they're going to be estate taxes when you die, that life insurance could help pay the estate taxes. That's number one. Number two, we don't know where insurance companies are going with COVID. If you had COVID, even though you're cured, how's that going to affect your getting insurance in the future? Okay, it's a brand new area. We have no idea. So I'm recommending people don't do anything with your insurance right now. Now, if you know you want to keep it forever, but it's term insurance, almost all term policies are convertible to permanent policies that will last forever. So that's another option. It is more expensive to do. But if you have a health issue that would cause you to get insurance at a higher rating today and have it be more expensive, but you have term insurance, you could convert that term insurance to permanent without a medical exam today. So that's another reason. Doesn't mean you have to run and do it, but it's something to consider. So I recommend not just getting rid of life insurance, seeing what's going on. If you do have life insurance and you have a taxable estate, you should consider putting life insurance into an irrevocable life insurance trust to help avoid estate taxes on the proceeds. Because if you own the policy and the proceeds go to your kids when you die, those proceeds are includable in your estate for estate tax purposes. So if you're worth $11.5 million, you have a $3 million policy, you're now worth $14.5 million. The kids are going to pay tax on that $3 million policy. If you put into a life insurance trust for the kids, when you're gone, those are not part of your estate, and their $11.5 million won't be taxed if you die, and that's your exemption amount. Does that make some sense? I know I ran over that quickly, so did I explain that okay? All right, so basically when you look at estate planning, you have two parts to it. You have the what I call the fundamental, which is what everyone should look at. Do you use a trust? Do you do a will? Who do you leave your assets to? When do they get them? Who will be the trustees? With people living longer today, when I have clients whose parents are still living, I ask them, if God forbid you died before your parents, do you have to put some money aside for your parents? I mean, if you're helping them now and you die before them, you might want to have some money there to help them. So that's another factor. Every family is different. If your family, your parents are very wealthy, then no, you probably don't need that. But let's take that now and talk about something else. When I pass away and I leave assets to my son, Ben, those are his assets. He can do whatever he wants with them. Invest them, whatever. His three worst case scenarios are if he gets sued, he might lose them in a really bad lawsuit. We were talking about asset protection earlier. If he gets divorced, the spouse could attack it and say it's community property. And when he dies, it would be subject to estate tax when he dies. If we want to avoid that and protect him, instead of giving him the assets, we can put it into what we call a heritage trust for him. So the money goes into the special trust for him when he passes away. He can be the trustee of that trust and control the assets and invest them any way he wants. But as long as he leaves the assets in the trust, they're protected if he gets sued or divorced, and they won't be taxed when he dies. So if he gives
Doron, we have less than a minute, so we have to wrap it up.
Okay.
I'll pass on your information.
No,
it's
that's
not
fine.
that I don't listen to it.
That's fine. But okay, so let me just take this. So that heritage trust is a way to protect the inheritance. If you have family that's going to leave you money, and Jenny, this goes back to your issue, you might want to have them set up a heritage trust for you so your inheritance is protected if you have a concern about that. That's it, Andrew. I'll stop there.
Thank you, buddy. Thank you, everybody.
Brilliant. Thank you so much.
Everybody, thank you for your patience.